Okay, today we're going to talk about dealing with real estate agents or brokers as a real estate investor. This is a topic that I get a lot of questions about all the time, especially from investors who either A, are not licensed agents or brokers, and or B, are just kind of beginning and running into a brick wall dealing with real estate professionals, so to speak. And I have to be honest, I mean, I have my license. It's inactive at this point, but um, real estate agents can be your best friend or your biggest nightmare in this business. And I think you should strive to make them your best ally. And I'm going to give you some tips on how to deal with them to get them to be your best ally. Because I remember when I first came to Denver in 1993, and I had done some real estate in New York, where I'm from. And I recall going into one office after another office of real estate professionals and them telling me, well, that doesn't work here. You can't do that. You can't buy properties for a 20% discount. You can't get seller financing, that easily. You can't do creative stuff, blah, 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 all these things I couldn't do. And if I had listened to them, I might have given up, but I knew it worked. I knew it was just a matter of finding the right professionals to work with. And that's really the key here. So I'm going to give you some tips and then some things to look for in a real estate professional to work on your side. So let's start with the very basics of the game. Some of you may or may not know all this, but I'm going to review it anyway to make sure we're all clear about it. First thing, the difference between a real estate broker and a real estate agent. Now, the semantics are a little different from state to state. For example, some states it's a real estate salesperson versus a real estate broker, but the concept is the same. So when you first get your license as a real estate professional, you are what's considered either a salesperson or an agent. In Colorado, they call that a broker associate, but it's not really the same as a full broker. The full broker in all states is the sometimes called the managing broker, is the one who runs the office. So when you first get your real estate license, you have to work for a broker under their license for a couple of years, and then you can apply to become a real estate managing broker or real estate full broker, whatever they call it in your particular jurisdiction. And that allows you to hire agents to work underneath you. So not only do you get commissions on what you do, you get commissions on what the other people who work under you do. There's some sort of split usually. Now, it's morphed a little bit in terms of how it works these days. In the old days, it was almost a 50-50 split between the salesperson agent and the managing broker on the commission. And that's just on the selling side commission, not the full commission. And now a lot of brokerage offices are offering deals where you just pay a monthly fee, and then they take a small transactional fee, like $500 per transaction. So it's not as onerous as it used to be as a real estate salesperson agent working under a broker. Nonetheless, a lot of people don't bother getting their full broker's license because they just don't need to hire people under them. So so we have real estate agent, and I'm going to use this vernacular as we go from now on, even though it's different from state to state. Agent is the first license you get, allows you to list properties, sell properties, show properties, etc. And broker is the ability to do all those things plus hire people underneath you in your own operation. Realtor, which some people call realtor, just funny. It's not a realtor, it's realtor. Realtor is a trade name for someone who's a member of the board of realtors. And there's local boards, there's state boards, and then there's the national one, NAR, the National Association of Realtors. And it's a trade name designation. If you're a member of that, you can use the realtor brand in your advertising, sort of like being a member of the Better Business Bureau. It's not required. And it's not required as a real estate broker or agent to be a realtor. Although in many states, a lot of the local multiple listings services require that you become a member of the local board, in order to use that system as a broker or agent. But that's been relaxed quite a bit. And I think the newest NAR settlement, the big lawsuit, eliminated that altogether. And then there's either one, whether it's a broker or agent, can be a listing broker or agent, or can be the buyer, or sometimes called the procuring agent. That's a big word, or selling agent. So the listing agent lists the property for the seller for a fee that they agree upon, and then the buyer's agent or buyer's broker, or sometimes called the selling agent, brings a potential buyer in to see the property, makes an offer through the listing agent who works on behalf of the seller. So there's two different professionals working on behalf of the two different parties. Okay. So that's basically, the gist of the basics. You understand we have agent, broker, realtor, and then listing versus buyer's broker. Now the fees, this is part of the NAR lawsuits that was settled, was usually it used to be 7%. That was kind of like the industry standard, and the National Association of Realtors got a lot of flack about that because it seemed kind of like a price fixing thing. And then it became 6%. Although a lot of real estate professionals, you can negotiate that. 6% of the sales price is the fee, which on a $500,000 house is 30 G's. That's pretty steep. Especially because the listing agent, I think their job in this market is a lot easier than the buyer's agent, because there's so few properties that once you get a listing, you don't have to do much. You take some pictures, throw it on the MLS, and then the buyer's agents are going to bring their clients in to see the potential property and see if they want to make an offer and compete, with each other sometimes because there's so few properties. The key job of the listing agent is to make sure, number one, the listing is correct, accurate, appealing, the pictures are good, and most importantly, it's priced right. Because if you don't price it right, you price it too high, what you're going to do is end up dropping the price over and over until you end up selling it for less than you had originally listed it for the right price in the first place. Sometimes the client, the seller, pushes the agent, but the listing agent, should be firm about, this is the real price. You don't want to go too low and give it away. You don't want to go too high either and then start dropping it, because the listing gets stale, and then everybody sees it over and over, and then they end up selling for less than if they had priced it appropriately to begin with. So his or her fee, the listing agent, is paid out of the proceeds of the seller's sale. So if the seller receives money at closing, presumably, they would pay out of those proceeds the 6% to the listing agent. Now, if there's another agent, a buyer's agent, and it's not always the case. Sometimes a listing agent might have been lucky enough to list it and also get a call from a buyer directly without an agent themselves and get the full 6% or 5%, whatever they've negotiated. But usually, even though the buyer's agent represents the buyer, they're getting paid by the listing agent, who splits part of their commission. So if it's 6%, usually it's half and half to the listing agent, half to the buyer's agent. But sometimes a listing agent can offer more than 3% to encourage more showings from potential buyer's agents. And buyer's agents shouldn't really be doing that. That is, showing properties that aren't in their client's best interest. But they might say, hey, just for kicks, look at this one, because I'm going to get 4%. So that's generally how it works. Now, the NAR lawsuit thing changed that slightly, but as a practical matter, nothing much is really going to change in the business. So I don't expect lower fees. I don't expect much difference in a way that agents and brokers operate. Some logistical things that they're going to have to jump through a few more hoops and forms, but it really didn't change much of anything, if anything. Okay, so let's go through. I have 7 rules of dealing with real estate brokers and agents as a real estate investor. So rule number 1, make sure the brokers or agents get paid. That might seem like an obvious one, but if you're making a cash offer, whether it's high, low, or medium, the seller's going to have proceeds to walk away with, presumably, if he's got any kind of equity in the property, from which the listing and buyer's agents get paid. But if you make an offer, let's say on a property, let's say it's free and clear, and you make an offer with no money down, owner carry, well, where's the cash to pay the agents. Now, in theory, the seller could reach in his pocket and just pay everybody, but it's not likely that the seller is going to want to do that. So make sure whatever offer you make, if it's something creative out of the box, make sure there's enough money in there for everyone to get paid. Now, does that mean everyone gets paid full? Not necessarily. If you offer something like a subject to or a lease option or a wrap or something creative, you might call the listing agent directly without your own agent and say, I assume your listing commission is 5 or 6%. I can't afford to pay you 30 grand, but this is a slam dunk deal where we don't need bank approval and it's owner carry, so we'll close quickly, you'll get paid quickly. So how about I just give you a flat 10 grand instead of the 30 grand? And you can negotiate those things. You can negotiate that. But make sure whatever offer you make, the real estate professional looks at it and says, well, wait a minute, how am I getting paid out of this? You want to get them to cooperate. Now, in theory, they have an ethical duty to present all offers to their client, the listing agent, that you make. But if you make an offer that they consider silly or one which they're not going to get paid, they're going to treat that with a lot of skepticism, may not even present it to their client, which is unethical, or present it to the client in a way that says, well, we got a dopey offer. Are you interested? That kind of attitude. So make sure all brokers or agents are getting paid. Okay. Next, number 2, make it easy on the broker or agent. Too many people hire a buyer's agent and then they say, okay, let's drive around and look at property after property after property that's listed, mostly properties that are vacant, maybe need work, etc. That's a lot of work for a real estate agent. Remember, the agent is not working for free. They're going to get paid, but they don't get paid till the deal closes. And if you're an investor going to making low ball after low ball offer, and after 5 or 6 or 7 offers that this agent has made, and he showed you the property 6 or 7 different ways, and then it's not closing, it's not getting accepted or closing, you're not going to get a lot of cooperation from that type of person. So make it easy on them. What I would suggest you do is just ask them to print you out a list of potential things that might meet your criteria. Get in your own car and drive by the properties, at least examine them from the outside, the neighborhood, the block, just to weed out. I bet you if there were 10 potentials, you'd probably weed out 7 of them and really want to look at 3. So don't make them drive you around and look at properties. Make it easy on them so they don't have to do a ton of work. Rule number 3, let them think or know, depending on what you are, that you're serious. Okay. So a lot of people come out of a seminar or read a book and, they think they know a little bit about real estate and they start talking in a way or using words or using language that an experienced real estate professional is going to go, this person's not serious. They're not serious. They're a total amateur. They're a newbie. I'm not wasting my time with them. So you got to let them know that you're serious. And the way to do that is to understand, the lingo, the vernacular, the customs, and talk like you're a big shot, even though you may not be yet, but fake it till you make it. Also, the prospect of repeat business for them is something that may turn them on. Although if they're making a dozen offers that don't get accepted, I don't know how excited about working for you on a regular basis is going to get them excited. The thing is though, let's say 1 out of every 30 offers that you make, if they assume they're cash or lowball or creative finance offers, even gets a reply, a counteroffer. The agent's not going to be real excited about continuing to work for you because there's such a low percentage of closing and low percentage of fees. So what I recommend you do is if you're going to play a shotgun game where you just bang out dozens of offers every month, offer to pay the real estate agent who's preparing the contracts, your agent, a per house or per contract fee. Now, these days it's very easy because it's automated. You have software that you just go click, 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 and they email you the contract for e-signature, and it's real easy. They don't need to meet with you necessarily to do it, to get a signature. So maybe you say, okay, I want to make a lot of offers, and I understand your time is valuable. So I want to make 30 offers a month, and I'll pay you, let's say $40 or $50 for each contract you prepare, whether it's accepted or not. So at least they're getting paid for their time. And I mean, it shouldn't take an experienced real estate professional more than, once they get the basic info about your company and such, into their database, it shouldn't take them more than about 15 minutes to prepare a contract. So at least they're getting paid, if you're paying them 50 per, that's 200 an hour. That's not bad. It's something, at least you're showing respect for the agent's time and that you're serious about using them regularly. Rule number 4, know the contracts the brokers use in your locality. This is really important. It's so often that people get a contract off the internet or even for one of my courses and they're submitting it to a listing agent on a non-standard form. Now, in some places like California, they're a little more lax about that in practice because there's no state approved form in California, where, like in Colorado, there's a state approved form that all the brokers use. In California, the California Association of Realtors has their contracts, but a lot of people use other ones, so it's not uncommon to see a different contract. However, if you're dealing in an area where everybody uses the same standard broker form, then learn the standard broker form and just put an addendum on the form with the clauses and things you like, and strike out the ones in the main contract that you don't like. So at least you're showing that I'm playing within your rules, within your game, within your guidelines. I understand that anything that is out of the ordinary as a contract probably requires an attorney somewhere in there, because brokers in most states can't review contracts or prepare custom contracts or addenda and so on and so forth. They'll come up with their own clauses and things. So know the contracts, learn them, learn what things you want to remove, and then you have an addendum that you can add on to that contract. Rule number 5, offer a reasonable earnest money. As I've said many times, when you're dealing face to face with a seller, no brokers involved, it's real easy because you can whip out your own contract if you like. There's no standard form for that. And on the earnest money line, how much earnest money you're giving as buyer, it could be as whatever the seller agrees to. So if the seller's pretty motivated, you could put $100. If he's moderately motivated, maybe $500. Whereas a listed property that's $500,000, they may want 5 or 10,000 earnest money. Now, does that mean when you make an offer on a listed property that says minimum earnest money 10,000 that you must put up 10,000? No, it's not a law. It's just, this is what I'm considering to be a serious offer, 10,000 earnest money. Does that mean you can't offer 5,000 earnest money? Of course not. Of course you can do that. In commercial deals, it's very common for earnest money to be paid in chunks on different timelines. So if it's, let's say, 50,000 earnest money on a commercial property, maybe 15 now at signing, another 15 after the inspection contingency is resolved, and then the rest when the loan approval comes in. Okay, so you're paying it over in chunks as you go, and you could certainly do the same thing on a residential deal. If they want 5,000, I'll give you 2,500 now at signing of the contract and 2,500 after the inspection contingency is resolved. Now, if the inspection contingency results in a disagreement where you're entitled to your earnest money back, you're going to get it back either way, all of it. However, as a buyer, you may not want to tie up all that money, or especially if you're wholesaling it, you may want to, during the, let's say, 10-day inspection period contingency, find someone else to wholesale it to, right? And then get paperwork with that person who gives you 2,500 or 5,000 earnest money. And that way you can replenish your cash without being tied up all the way till closing. But if you offer on a listed property $100 earnest money, they're just going to laugh at you. Don't do it. Number 6, demand the right to use your closer. This is so important. Now, it is customary in most cases that the seller, more likely the seller's listing agent, is going to pick the title company, attorney, escrow company who does the closing. Now, your life will be a whole lot easier if you use someone that you know, who understands the way you do things, who is favorable to you, who returns your calls. it's perfectly okay in your offer to say buyer reserves the right to choose the closer, the title company, let's say. Now, there's two main fees in the closing. There's a title insurance fee, which is the big one, several $1,000s. And then there's the actual closer's fee, and that's to prepare the closing documents, sit down with everybody, collect and disperse money. That's called the escrow service. So title companies in most states do both title insurance and escrow. In some parts of the country, attorneys do escrow and separate title companies. And in places like Southern California, they use escrow companies separately from title companies. So the escrow company performs the closing service, the title company issues the policy. So let's say that the closing fee is $500, which is normally split 50-50 seller and buyer. That's $250. If you just say, I want to use my title company to close it, you might get pushback from the listing agent. If you say in your offer, I'll pay the whole $500, my $250 and your $250 for the right to use my own, that may perk up their ears, and they may back off on their obstinance there. If they still make a stink, offer to pay for half the title policy too. It's worth it to pay an extra $1,000 or more to control the transaction is so worth it. So, in your offer, you can put in there, as the buyer, have the right to choose who closes this transaction. Otherwise, if you're doing something out of the box, every time you do a transaction, you're dealing with a new closer that the listing agent picked that may not understand the way you do things or be willing to do it the way you do things. And then finally, number 7, know the difference between customary and the law. Now, this is a big one because when you're dealing with agents, a lot of times the very experienced ones and sometimes the not so experienced ones who think they know it all. And by the way, I'm not picking on agents and brokers in particular. Attorneys are just as ridiculous. They think they know it all, even more so. They may say, well, that's not the way it's done. You can't do it that way. And they may even say that's not legal. Well, there's a difference between what's customary practice and what's the law. So, for example, picking the title company to close it is customarily the seller's pick. That doesn't mean the buyer can't pick it. So anything that's customary is negotiable. The law is different. Okay. So when for example, a listing agent says, well, you can't do that, that's not legal. You ask them a simple question: what law prevents me from doing so? What law prevents me from doing so? And usually they don't have an answer, or they'll want to talk to their managing broker at their office who doesn't have an answer either. So be willing to be firm. You don't have to be obnoxious, but if a real estate professional says you can't do that, ask why. Well, that's not the way it's done. Well, that's all negotiable. But if they say it's not legal or that's illegal, you ask them what law says that that's illegal. What law prevents me from doing so? And they usually don't have an answer to that. And sometimes you may be wrong. There may be a law, but more often than not, it's something where it's just they're not familiar with that. It's not the customary way they're used to doing things, and they try to bully you by telling you that's not legal. Okay, so know what's the law, know what is customary, and be willing to push the envelope especially on the customary things to inure to your benefit. Okay. Finally, lastly, one last topic I wanted to cover that wasn't in this is, should you get a real estate license as a real estate investor? Well, let's look at the good and bad. Having a real estate license gets you access to the multiple listing, which is very valuable. Number 2, it's going to get you more cooperation of other brokers and agents. So if you, as a direct consumer, individual investor, call up a listing agent and say, I'd like to look at the property, I'd like to negotiate something, they're going to treat you differently than if you call up and say, I'm a real estate broker or I'm a real estate agent. You're going to get, it's more women probably, but the good old boys club, so to speak, or a good old girls club, or the insiders, let's say, treatment versus the you don't know what you're doing here. You're not a professional kind of attitude, sort of like attorneys do to lay people. And that's true. Lawyers sometimes respect or deal with other lawyers differently than lay people. It's just the way things are, and it's like that in many industries, many industries. Okay. Um, Now, the other good thing is if you had a property that you wanted to sell on the MLS, well, you get a commission off of it. And if you're buying a property that's listed on the MLS, you could represent your own company or maybe a company that's owned by your spouse and get a commission, splitting it with the listing agent plus whatever profit you make, what you do on the back end with the property. So there are advantages, disadvantage. Always have to disclose on all your letters, your marketing, your calls, whatever. You have to disclose that you're a licensed agent. Even if it's a company, you have to say that the principal or one of the principals is a licensed real estate agent or broker. Number two, sometimes people get suspicious. They go, "Oh, you're just trying to list my property." And if you couch it properly as, "Listen, I have a license, but I'm not looking to list your property in your marketing," um, most people are okay with it. Some people just don't trust brokers at all. So you're going to get that. But that's a small minority. And then there's probably an equal size group who would say, "Well, they're licensed, they're regulated, so I have more reason to trust this person than someone who's not." So I think they kind of cancel each other out. There's also the expense and time factor of having a license. As I said earlier, if you hang in your license with a broker's office, you're going to have to pay a monthly fee for the office. You have to pay for malpractice insurance, known as errors and omissions, and you have to do continuing education classes on a regular basis, which costs money and time. Also, if it goes to court, you're presumed the expert, and the other person is presumed the lay person, and therefore that could work against you in court. Then again, if it comes out at trial that you've been doing investing for 10 years and you've bought 100 houses, I think the judge is going to give the same treatment to you as you're the expert and they're not. So it kind of cuts both ways. You might want to think about it. I don't think it's worth getting a license just to get access to the MLS. But if you're going to use your license in a way that benefits your business, and maybe here and there you represent a client on a buy or a sell, could be worth your while. Could be worth your while. It's not that hard to get a real estate license. You just have to study a class. You can often do it online. When I did it, it took me about 2 weeks of online classes, and then I got fingerprinted, background check, took a multiple choice test that was about 45 minutes, and boom, you're in. I mean, it's a lot harder to get a haircutting license, but you can ruin people's lives pretty badly with a real estate license. Even a securities license doesn't take that long. A haircutting license takes like a year. Um, so it's not that hard to get the license. It's just a matter of whether you want the obligation, the potential liability, and the cost and time involved in having the license. But overall, I think it's a positive thing on balance. But I'll leave that choice up to you. So again, show respect for real estate professionals, even though sometimes they don't earn it. And try to work with them. Don't go around them on a listed property and go directly to the owner unless you feel that they're not telling the owner what you're offering. Then I think it's okay to bypass them, unless you're a licensed agent yourself, and then you're not allowed to do that. But if you're not a licensed real estate agent and the listing agent or broker says, "Don't talk to my client," well, sue me. Well, what are we going to do? You're not presenting my information or offers to your clients, or you're doing it incorrectly. So I'd like to do it. Final point: if you're going to make some sort of creative out of the box offer, other than strictly cash, I would ask the listing agent to meet in his office or her office with the client, the owner, so you could sit around a table and discuss it. Because if you make some, sort of creative offer, unusual offer, you're going to explain it to your agent. Your agent doesn't really understand it 100%, explains it to the listing agent, and something gets lost there by the time it gets to the owner. It's like the game of telephone, if you remember that as kids. Something gets lost there. Also, you don't know the motivation of the seller. And by meeting in person, sometimes the owner will spill the beans about the fact that they're getting divorced and they're in foreclosure. And that's not information you're always privy to on a listed property. So ask the listing agent, hey, I got a sort of unusual offer. I think it'll be easier if I just met you and your client in your office to explain the details. And most of them will say, okay, because they want the property sold so they can get paid. That's the bottom line. That's what they do. Put food on the table for their family. They get commissions. Technically, listing agents' obligation is to best represent their client. They got the highest price and blah, blah, blah. The reality is they're salespeople, and most salespeople are concerned about one thing: getting paid. I'm not saying that most brokers and agents are unethical and ignore their duties. I'm just saying they're human beings. That's all I'm going to say. They're salespeople. So if you appeal to the money side of it and getting paid as quickly and easily as possible, you're going to get more cooperation from real estate agents and brokers. And that's the bottom